Okay, good afternoon.
Good afternoon, Your Honor.
Good afternoon, Your Honor.
Okay, we're here on the case of Universal Engineering versus Sutherland. The other members of the panel joining me today are Judge Meredith Sasso, and then sitting in as Associate Judge from the 11th Circuit, we're pleased to have join us Judge Ramiro Arisas. Each of you have 20 minutes for your oral argument. The appellant is entitled to divide that time between opening argument and rebuttal argument. You should be able to see a clock there to help you keep track of time, but I can also help, so how much time does the appellant wish to reserve for rebuttal?
5 minutes, Your Honor.
Okay, and these oral arguments are being live streamed on YouTube and also being recorded so that the public can view them. Okay, appellant's counsel may proceed.
May it please the court. Good afternoon. My name is Alexis Cooper-Patrick, and I represent the appellant, Universal Engineering. The appellant is the former employer of appellee Phil Sutherland, and this matter arises out of the jury trial and final judgment that was entered. The underlying case, the final judgment that was entered was a breach of contract entered in favor of Universal.
Right into the issues in your brief. As to the FMLA claim, there is discussion in the, well, I'm not sure if I think it was the counterclaims in Mr. Sutherland's closing that Universal had stipulated to the fourth element of the FMLA claim just by making a request. So can you start out, one, was that stipulated to? And two, your argument as to whether simply making a request is activity protected under the FMLA.
Absolutely, Your Honor. That is the primary issue that we are here today to assess. That issue is, again, where it is undisputed that an employee has made a request for leave under the Family Medical Leave Act, the FMLA, but then fails to comply with the FMLA, with an employer's requirement for a medical certification. Does the request for FMLA leave, does it extend indefinitely? The answer to that is no, and Universal did not stipulate to an indefinite entitlement to FMLA leave.
Well, there's a difference between entitlement and retaliation.
Absolutely.
Well, if an employee makes a request under FMLA and then they don't submit the medical information, can you fire them at that time?
That is
because they did. Because they did.
Absolutely, Your Honor. That is the question here.
Why would you be able to fire them if they, engaged in an act which was permitted by the statute?
Absolutely. So the issue here is that Mr. Sutherland made a request for FMLA leave on January 15th. He was provided the forms on January 18th, which included, at the employer's discretion, a medical certification form. That form has a 15-day turnaround time and deadline. It's at least 15 days. Universal provided him with a deadline of February 4th, which was 17 days from the deadline. At the point at which Mr. Sutherland did not return the form, the medical certification form, did not ask for an extension, and did not otherwise alert Universal that he was intending to use FMLA leave at some point in the future or for some other reason.
Yeah, but the question is, could the employer at that time say, you know what, I'm just incensed that this person would ask for leave under the FMLA, under that act. I think that act should never have existed. I'm incensed they did it, and I'm just going to fire them because they did. Is that permissible under the statute?
No, Your Honor. I don't believe that.
Okay, so does the fact that the certification, how is that relevant?
Absolutely. So the relevance of the certification is that the certification form identifies within it on a doctor or other medical professional is supposed to identify the length of time, the amount of leave necessary, and when that leave would be necessary for the employee to take. And that's relevant here because the alternative and what Mr. Sutherland is espousing is that the FMLA leave protection is indefinite. And there is never a point at which not returning that form cuts off your entitlement to FMLA leave. And here,
the cases you cited were situations where the person did not cooperate and provide the information and then didn't come to work. I mean, that's not what happened here.
Sure. So in this instance, there is a big distinction between failing to return a medical certification form, which effectively terminates any rights to the FMLA leave.
Right, but let me go back to my original question.
Sure, Your
I'm
Honor.
not sure I got an answer. If the employer does not return the medical information, can the employer say, I'm going to fire him anyway, just for the mere act of requesting it?
Well, Your Honor,
yes or no?
We believe that he can be terminated for any reason after the deadline has passed and no extension was requested.
So you're saying that an employer could fire him after the time, to provide medical information was not met, that the employer could say, just because he made that request, I'm firing him for that reason.
Yes, Your Honor, but I think that in the instant
Okay,
case,
if that's your answer, okay.
sure, absolutely. I think in the instant case, we have a situation where this is an employee who had previously taken leave subject to FMLA, I believe about 6 months prior to this second request. And the medical certification form was returned.
But Ms. Patrick, I apologize, but I think what Judge Evander is getting at, and I have the same question, is that there is a difference between someone who is requesting the FMLA leave and whether or not they're entitled to that leave, and whether or not they are retaliated against for attempting to use the FMLA leave. And so there is a difference. So let's say, for example, he had gotten you the medical forms, and for whatever reason, he did not qualify for FMLA leave. Can he be terminated for having attempted to use it? And if so, why is your case different from that hypothetical?
Absolutely. I think here, the difference between attempting to take FMLA leave and what Mr. Sutherland actually did, which was taking FMLA leave within a period of a finite period of time. He made a request saying that he needed to take FMLA leave. He was provided the document that had a 17-day deadline. And at any point during that, I would agree with you. If he had said, I'm not taking this leave now, I'm going to take it at some point in the future, which is unknown, I think that's where you get into attempting to use or exercise your FMLA rights and the protection that comes in there. But that was not the circumstance here. This was an immediate need, followed by a 17-day period in which he had to return this form to identify how much time he needed, where he would be. There was a lot of different questions that the medical certification that it answers to the employer to discourage fraud. There's a ton of reasons that this was included in the original legislation. Now, here we have a situation where, again, he did not, like the Pareda case or some of these other cases, he did not say, I'm going to take this at some point in the future. He had an immediate need for it and could have at any point during those 17 days reached out to the employer and said, I don't need this now. I need this at some point in the future.
Let me ask you this. Was there evidence that the jury could conclude that your client had decided to fire Mr. Sutherland even before the time in which to return the medical paperwork had lapsed?
No, Your Honor. February 4th was that deadline. The testimony is clear at trial that the decision to terminate Mr. Sutherland did not occur until Monday.
Well, how about the two employees that said it had occurred prior to that Monday,
The two employees who at deposition believed it had occurred that Friday. The deadline was the 4th, which was Thursday, 2016. And that conversation, again, based on that was contradicted at trial, that occurred Friday, February 5th, 2016. So again, to answer your question, no decision, even assuming the worst for Universal, no decision had been made prior to the passing of that deadline. And again, that is our position, that deadline is a hard line in the sand. And once we go past that, any right to that protection is extinguished, because the opposite of that is very concerning. It is an unprecedented expansion of an already very protective law for
Do you have any
employees.
case law that supports your argument? They've cited cases that go the other way. Do you have any case law that supports your position?
Well, I think that the cases that they support typically are a situation, as we discussed before, where there is a attempt to exercise the rights in the future, not exactly identifying when that will be right. But in the case of Pareto, where a woman is pregnant and it is anticipated that in 9 to 10 months she would be needing leave, that's one situation. Our cases fall much more in line with the idea that this is a cooperative activity, exercising FMLA, that it requires cooperation from both the employer and the employee. And that is the Motter case out of the Fifth Circuit. We have Gonzalez, which we have relied on, which is that a failure to comply with the certification requirements renders an employee unprotected by FMLA. That cites to the Baldwin Love case, which is that there is, as we said here, a very big distinction between failing to return the medical certification altogether, or in other cases, such as those cited by Appellee, we have situations where there's an insufficient or incomplete form. That's not what we're dealing with here. Although, as the facts indicate, Mr. Sutherland was terminated Monday morning. And then later that afternoon at about
Ms. Patrick, I'm sorry, but you're using a lot of different facts. You're comparing the facts of this case to the facts of other cases. And I guess what we're asking is, what is the law in this scenario? Is there a bright line, or does it matter, like you say, that in some of these other cases, more time had passed, or it was for requests that were in the future? Or is it that if someone just either messes up and doesn't get you the right form, or perhaps they want leave for a family member or person who's not covered under the act, that once they do that, and once it's found to be insufficient, either because they didn't get you all the information or because they don't otherwise qualify, that's it. Even if they're fired, they can't raise a retaliatory claim.
Sure. I think that there is no case directly on point here that identifies after failing to return a medical certification form at one moment in time, those rights are not extinguished. That obviously, I think, would be extremely helpful here. But what we do have are cases in which people fail to return the certification forms at various points in time, and those rights have been cut off. We have, the Clegg case, which identifies that if an employee never returns the form, that leave is not considered FMLA leave. The distinction here between the cases that we cite and the cases they cite, again, is really an issue as to if a document is not submitted to the employer and there is no extension request made and there is no otherwise identification that they're having trouble returning it or anything like that, how is the employer supposed to know what that leave is actually for? That's what the employer that's why they're able to identify that a medical certification is needed.
Another question, even accepting your argument that this leave was not an FMLA leave, as you know, from our standpoint, we're supposed to, give every reasonable inference in favor of Sutherland. So why could the jury in this case, when the statutory language of FMLA provides that he was required to comply with the 15-day rule unless it's not practical under the circumstances with good faith efforts, why could the jury not have looked at that in the statute and determined that he was making good faith efforts to get this completed?
Understood. I believe, Your Honor, that we think that this is a purely legal issue that should have been handled at summary judgment. It's worth noting earlier in the case, this motion at summary judgment was granted. It was then reversed, and then the jury trial continued. We repeatedly requested throughout a long period of time with several different trial court judges that we rebrief and rehear this motion for summary judgment because we think it is a purely legal issue applying the facts.
If the jury found it was impractical, for various reasons not to have it done within that time, are we required to give that finding deference if there's evidence to support it?
Well, we don't believe that there was any evidence that it was impractical, because if there was evidence, when asked at trial, Mr. Sutherland said he did not request an extension. And I can't think of a single other piece of evidence that was introduced indicating why it was impractical for him to return it. Additionally,
wasn't there a lot of evidence concerning what he was going through with his wife at the time, and that they were attempting to get these forms from the doctor? His wife, I forget exactly what the condition his wife had, but she had a very serious condition. They had the same doctor. They were trying to get the forms done, but he was also caring for her. Aren't those the sort of facts that the jury could have considered and said, you know what, maybe it wasn't practical that he get it in by the 4th. He got it in on the 8th.
I think that again, looking at the facts as Universal, as the employer, taking a look at whether they believe that this was FMLA leave, they had none of that knowledge. None of that was communicated, and there was no evidence.
That's not the lens that we're supposed to view it from, though. We're supposed to view it from the reasonable inferences the jury could take. So why is that evidence insufficient for the jury to conclude that he was making these good faith efforts?
At the point at which the form eventually did come in, and it is worth noting that that is insufficient and otherwise not complete. That form came in after the point at which Mr. Sutherland had already been terminated. And so, there is a question there as to, this is a person who, again, had completed a certification one time previously, knew where it was supposed to go, and knew that he could ask.
Okay, Ms. Patrick, let's forget the form that comes in late. Let's assume he never submits a form. Why couldn't the jury have used the facts that I just discussed and said, under the circumstances, he was terminated before he was ever able to actually turn in those forms because of the circumstances?
Well, I think why that's important is because then we shift to an analysis of the reason for his termination. And so if you were looking at, again, assuming giving them the benefit of the doubt, if you're looking at the reasons that Universal set forth for terminating him, not having that form returned, not having any discussion with anyone at Universal as to why the information, could not be, at that point, Universal's knowledge was that he no longer had FMLA rights. So there couldn't be a termination as a result of that. They believed, and the evidence is there as well, that he was no longer seeking FMLA leave.
All right, you're 3.5 minutes.
Yes, thank you. So the other remaining issues, obviously, that were briefed in our initial brief, deal with the final judgment that was entered as a result of the jury's verdict. And Universal moved for additur and remittiture in a post-judgment motion, which was denied without any explanation, which is why we believe this is an abuse of discretion. Under 768.74, Universal, I guess the first portion of this that we believed was improper was the entry of an award of 0 damages for Universal, despite Universal's, the judgment in Universal's favor that Mr. Sutherland had breached his restrictive covenant with Universal in the employment agreement.
The jury was instructed on that issue that if you find that Sutherland breached and that damages cannot be reasonably ascertained, was the jury required to, if the jury found both those, if the jury found that he had breached, but that damages could be reasonably ascertained, was the jury verdict a proper one?
That is possible, which is why part of the reason that we moved for additur was as a result of the undue influence that the jurors received as a result of Sutherland's constant references.
Well, let's leave those out of the equation for a minute. They weren't objected to, but I'm just asking, if the jury found from the evidence that damages could be readily ascertained, does that, could the jury properly award no damages?
Well, respectfully, Your Honor, it's difficult at this stage to gauge what the influences of those factors that I was discussing, how that factored in. Discussions of wealth and impact financially could have led a jury to determine that a company of this magnitude did not need any damages. We will never know. That's the problem, and that was the basis for our motion for additur. The uncontested evidence was introduced that this was a difficult thing to determine as far as damages in restrictive covenant situations. And that's why Universal had a liquidated damages provision for $5,000. That was the information that was presented. And so
I'm sorry, but even that liquidated damages provision, I have it here, reads, in the event that the damages suffered by the corporation cannot be ascertained with reasonable certainty. And so even in the language of the contract, it requires that there be some damages and that they not be readily ascertainable. So how do you square that? How do you square that with multiple references throughout the trial that there were no actual damages, that you couldn't actually prove that anything had happened? Why couldn't the jury have done as the judge instructed, which was one of the instructions they received was to recover damages from Sutherland for breach of contract. Universal had to prove all of the following: that they entered into a contract, breached the contract, and that Universal was harmed by the breach. So if you take that instruction together with the contract provision, why couldn't the jury have said, we've ascertained their damages, the damages are zero?
may I answer?
Yeah.
Yes.
The issue that we have here, I think, is best reflected in the statement by the trial court, which, to quickly paraphrase, he indicated that that if there was judgment entered in favor of Universal, some damages must have been found. That's a necessary element there. So that's why we think at a minimum, nominal damages should have been awarded instead of an entry of zero.
All right, thank you. You have I'll give you 1 minute for rebuttal. All right, for appellee.
Yes, good afternoon, Your Honors. May it please the court. And happy holidays, by the way. The clock is no longer showing up on my screen. It dropped off somewhere. So
Okay, you're at 1950 right now.
could somebody perhaps cue me at 5 minutes?
Will do. Okay.
Thank you very much. Your Honor, this case has a very unusual procedural history. We had an unusual number of continuances for a number of unusual reasons before getting to trial. But once this case got to trial and on this appeal, it's actually a pretty simple case. And that is in large part because of all the numerous factual stipulations that were entered into by the parties. And there's already been some discussion about that. The parties literally stipulated to 6 of the 7 elements of an FMLA retaliation claim.
They didn't stipulate to the 4th, though. The jury was instructed on what elements were stipulated to. And although I think you characterized the stipulation that a request was made as also a stipulation that the 4th element was stipulated to, that's not how the jury was instructed, and that's not necessarily how the stipulations played out.
I agree, Your Honor, that is completely accurate, and I would address that in greater detail. So that's true. The actual stipulation, they stipulated that Mr. Sutherland made a written request for FMLA leave on January the 15th, 2016. So that is the factual stipulation, but there is no doubt under 11th Circuit law that that stipulation is essentially a stipulation to protected activity. So in our brief,
Is it your position that once a request is made, they're indefinitely protected for retaliation?
I wouldn't say indefinitely, Your Honor, but first of all, it would be subject to proof. So if an employee makes a request, verbal or written, they don't have to specify FMLA. They don't have to even be definite. They can say, maybe in the future I might. Once that conversation has taken place, that's when the protection kicks in. And if the employee is subsequently subject to an adverse employment action, they can bring a retaliation claim. It's subject to proof of the motive. I would note that in such
let's talk about this case then and the proof here. Do you agree that that Universal would have been justified in denying the FMLA request the day after the certification was due?
Absolutely not. The FMLA.
Why not? What case supports that proposition? That they would not be justified in denying it? Sure.
Specifically, I'd cite to the statute itself and the implementing regulations, which say, well, it specifies what is necessary for a cert to be considered sufficient. And then the statute on its face says, if the employer believes that the certification is not sufficient, the employer has to give written notice to the employee and a 7-day.
That's certification that's received and insufficient. What about
Right.
certification that is not received at all?
It doesn't,
No requirement that the employer go back and notify them that it was late and give them a time to cure certification that wasn't received at all.
to submit it late. I don't think there is, Your Honor, but that conflates the issue of whether the employee is then entitled to take the leave.
Yes, and I agree there's entitled.
Is
I'm trying to, I guess what I'm getting at is, let's say I think they would be entitled to deny it at that point. That would render the leave unprotected, right? If they were justified in denying it at that point, it would no longer be FMLA leave in the sense that it was unprotected. So, and I understand you disagree with that point, but let's take the assumption that it was unprotected leave. How could unprotected leave give rise to a claim under the FMLA if it's not protected activity?
It's completely irrelevant, Your Honor. So all the cases that have been cited in the briefs, again, the arguments that Universal makes in every single case that they cite stands for the proposition that failure to submit the certification or submission of one that's insufficient in some way makes the leave unprotected. Okay, that's relevant to an interference claim, whether or not the employee is entitled to take the leave and whether the leave, if they are absent from work, is protected, and therefore whether they can be terminated for not showing up at work without a sufficient excuse. That is completely different from whether the employee is protected from retaliation for having requested the leave. That, under the law, as a matter of law in the 11th Circuit, if an employee makes a request for leave and the protection kicks in, as a matter of law, if a subsequent adverse employment action can be inferred to have been retaliatory if it takes place within a temporal proximity of up to 90 days.
If
to determine that.
Was there any evidence here that the decision to terminate Mr. Sutherland was related to the request, or was it related to the unexcused absences?
First of all, there is absolutely no evidence that it was related. Well, okay, let me back up. There were no unexcused absences. So that is another key distinction between every single case.
Yeah, and that's a term of art. I shouldn't have used that term.
He wasn't absent. He never took the leave.
Right.
So he
right.
did.
So was it?
He did. He never. There was never an argument that he stopped going to work for whether it was approved or not approved, because he never stopped going to work. There was no leave to be approved or not approved. It's kind of a double if. I mean, if he had not shown up for work, there's no indication, which is clearly not the case, there's no indication that that's the reason that he was fired. Universal gave a whole lot of other conflicting reasons for why he was fired. That may be the only thing that they never did say is why he was fired. So again, I think every question that all of your honors have asked about this issue really hone in on what I think is the critical distinction in the arguments being made here. Their argument would be at least a viable argument if we were talking about an interference claim. An interference claim is, okay, you've asked for leave. The employer is entitled to ask for the certification. If you don't provide it or it's not sufficient, then yeah, they can deny it subject to all the other specifics of the statute. But that is an entirely different question of whether once that request for leave is made, they can if there's evidence of it, if they can retaliate against the employee at any time in the future for having made that request. So perhaps it is indefinite. I honestly believe, and I've never seen a case otherwise. I mean, if somebody's fired 2 years later, if they can meet all of the other elements of the claim, now a jury might not buy that. Well, you made the request at this point in time and you didn't get fired till 2 years later.
Is the inference only for 90 days as far as any type of inference that it was retaliation?
That is an inference as a matter of law. So
it's beyond 90 days. You have
it's still subject to the jury's determination, right? If you get to the trial, so if you make it to trial and the evidence is presented to the jury, here's the request where the protection kicks in. Here at some future point in time is where the adverse action takes place. And then the plaintiff presents whatever evidence they can to convince the jury that that's why he was fired. I don't think there is a time limit. I think it loses credibility the further in time you go out. But the fact that within 90 days, that inference can be made as a matter of law, absent any other evidence whatsoever of an intent to retaliate. So, and in this case, there was a ton of evidence of pretext and of other things that point to the actual motive. If I could, there's only one case that I really want to cite from, Your Honor. It's on this exact issue. It's the one case I could find that is directly on point where the court, and this is Epperson versus Evanick from the District Court of Alabama, where the court makes the distinction that I am making. The arguments that they're making are relevant to an interference claim. And so in Epperson, the plaintiff made both claims, and the court said in differentiating an FMLA retaliation claim from an interference claim, he says, on the other hand, to state a retaliation claim based on a request for FMLA leave, a plaintiff does not have to show that he was entitled to FMLA leave at the time of the request. He only needs to show that he engaged in protected activity protected. Although his entitlement to the leave was subject to his eventual compliance with the request for medical certification, his request.
So what evidence do you think in this case supported an inference that he was fired because he made the request?
So, Your Honor, that goes to one of the other specific arguments in the case. Absolutely. And first of all, the standard for that issue in the 11th Circuit is not McDonnell Douglas, as plaintiff as they've cited. It's the convincing mosaic. So basically, the standard is whether the jury determines from just an overall mosaic of circumstantial evidence that they can make an inference that the motive was retaliatory. And the jury was specifically instructed, and this is from the pattern 11th Circuit jury instruction, that if the jury does not believe the reason that is proffered by the employer for the termination, that in and of itself is sufficient for the jury to infer the retaliatory motive. In this case, number one, there is a ton of pretext evidence, and I won't even go through all the rigmarole where they never even gave a reason until they were compelled to in discovery. And then in seeking a continuance, they came up with a completely different reason for why he was fired, while in the exact same document, they claimed that he wasn't fired at all, that he resigned. And then later at trial, they abandoned those and went back to the original reason. And I think one of your honors pointed out what I call the big lie, the story told by the two principals, Mr. Israel and Mr. Derrick, about what happened on that one day, February the 8th. Whatever happened, whether he was fired or was terminated, those two men say it all happened that day. They had some meeting with him, there was some disagreement, and either he was fired or he resigned. However, those other two employees testified, as one of your honors pointed out, that they were told that that decision was made the prior week, and not just specifically on Friday. The HR manager testified he was told sometime that prior week, he doesn't know exactly what day, that he was going to be fired on that Monday, and he was asked to prepare the separation agreement to have it ready. The other employee says he was told on Friday, that's true, but it was so specific to him that he was sick to his stomach all weekend long, knowing that his friend was going to be fired. In addition to the pretext evidence, Mr. Sutherland testified when he first made a request for FMLA leave, it was denied by his direct supervisor, and he had to go to the HR guy to get it overruled. He testified how, in his view, he was treated differently when he returned from that first leave. Again, the temporal proximity, which I've already talked about, is sufficient in and of itself to support that. And then the last thing I would mention is Mr. Derrick's, what I call the light bulb testimony, where he was asked after 9 years of Mr. Sutherland with a literally unblemished record, which was conceded at trial, when was the first time that there was any discussion of any concerns about his performance? The answer from Mr. Derrick was the light bulb went off for Mr. Israel, the head of the company, in September of 2015. That is exactly the time that Mr. Sutherland was out on his first FMLA leave.
That leave was not FMLA because it was for a mother-in-law, isn't that right?
Technically, that is correct, but they granted it as FMLA leave. And I think that the jury, as the court said, could certainly look to how the employer reacted to that to determine elements of motive and their response to employees taking FMLA leave. But I mean, I could talk about the pretext evidence and that evidence all day long, but I think there's so much there. I don't want to waste too much time on that. But again, I think, and I didn't get to quote all of it, I know it was a long quote, but the Epperson case answers this question very explicitly about the difference between an interference claim and a retaliation claim, and why the medical certification is completely and totally irrelevant to a retaliation claim. And the best evidence of that is just look at the jury instructions. So you have page after page after page of the 7 elements of an FMLA jury instruction, and nowhere in any one of any of them does it say anything about the medical certification, or you could even infer anything related to the medical certification. The only thing that's required in the jury instruction to constitute protected activity is that a request for FMLA is the exercise or attempted exercise of FMLA rights. And case after case after case in the 11th Circuit, most specifically the Pareda case, go on and on about kind of how loose even that requirement is. And what Mr. Sutherland did by making a written request specifically for FMLA goes way beyond what all the case law says is necessary in order to make that protection kick in. And your honors asked a question that I don't think there was an answer to. I'm not aware of any authority that says that you ever lose that protection. I don't think you do. I think it might be subject to proof and the weight of the evidence, but once you have that protection, and in the future, some subsequent adverse employment action takes place, if an employee can present evidence to meet all the elements of a prima facie case, then it's up to a jury to decide whether they believe it was the improper motive that caused it. So
Let me ask you this. First of all, you're 443, but what's the purpose of the medical certification?
The medical certification is to so-called justify taking the leave.
And if there's a stipulation, how, if any way, does the fact that there's a stipulation that his wife had a serious health condition, how does that play into the argument about the medical certification being relevant?
Well, that's relevant to the third element of the case of an FMLA claim, Your Honor. So entitled. So when the jury's instructed, so an employee has to be eligible, which was stipulated, he has to be entitled. What entitled means, an employee has to have suffered a qualifying event. And if an employee or a covered family member suffers from a serious medical condition, by statute, that is a qualifying event. So having stipulated that Carrie Sullivan suffered from a serious medical condition was in effect a stipulation that Mr. Sutherland was entitled to take leave. And at trial, not only did they stipulate that, that she suffered from a serious medical condition, but their HR director testified that the certification that was subsequently submitted was sufficient. It had everything in it that the statute requires. So there is no argument that it wasn't sufficient. It was sufficient. Their HR director sat on the stand and said that it was sufficient. So I may have short-circuited a couple of those statements about stipulations, but they did in effect stipulate to facts that as a matter of law under the 11th Circuit were effectively stipulations to all of those elements, except for the motive. And again, I could go on and on about the motive. I would like a couple of minutes, whatever I have left, to address the non-compete issue, Your Honor, unless additional. I think the court with its questions has hit the nail on the head here. Universal's argument completely ignores the actual language of the liquidated damages provision, which was incorporated into the jury instructions, which was incorporated into the verdict form. The part about damages being determined with reasonable certainty. This jury determined the damages with reasonable certainty, and they determined them to be 0. And the best evidence of that is that that's what Universal told them. Universal had sought damages throughout this case up until the opening statement. In the opening statement, their counsel conceded that they had no evidence that Mr. Sutherland had done anything that caused them any damage. Quote, "We cannot prove any damage." Mr. Israel said he did not know of any way that Mr. Sutherland had hurt or damaged Universal. And they affirmed that again in closing argument. So they stood there and said, we don't have any damages. And now they are appealing and saying that the jury got it wrong when the jury said you didn't have any damages. And so I think if you obviously just look at the language of the liquidated damages provision, the jury, it was incorporated, the jury got it. They read it, they followed it, and they got it right. And I don't think there's any basis for this court to change that. And I would also add that even if this provision said, if there's a breach, you pay $5,000, that would be an unlawful penalty under Florida law and Supreme Court decisions that I've quoted in the brief, particularly the Hutchison case. It's unlawful to award liquidated damages in excess of the actual damages. We know that the actual damages in this case are zero because Universal said so. So there is absolutely no basis to award the liquidated damages nor nominal damages. Your Honor, Universal never requested nominal damages. They never argued for it. They didn't lay any evidentiary foundation. I believe counsel made some reference to that, but there was no testimony about the damages being difficult to determine. They testified they didn't have any. And nominal damages is discretionary. Again, under the Supreme Court in Hutchison, and even in the pattern Florida jury instruction 504.11, nominal damages, even if they'd made the request, even if they'd been given the jury instruction, they would have been told that it was discretionary. And there is no basis for this court to, again, overrule the jury on that issue, even if it had been given to the jury, which it wasn't because they didn't ask for it. So, Your Honor, again, I don't know if I have any time left, but.
You're about at the limit. Any questions from the panel? Okay, thank you.
Thank you.
1 minute for rebuttal. You're muted.
I apologize, Your Honor. Thank you. As aptly identified here, the issue at hand is whether if an employee does not comply with the requirements under FMLA when seeking leave, are they entitled to indefinite protection? They answer yes, we answer no. I think that it is incredibly important here to look and see that there has not been a case cited that identifies that indefinite protection. Instead, the
person is pretty on similar to these facts. So would you distinguish Everson, or would you say that it was wrongly decided?
Yes, and I think that the Pareda case helps illuminate that, which even though this protection is afforded to people taking the leave in the future, it's very clear in Pareda where liability to an employee could also be denied for failure to meet other requirements. That is exactly what the issue is here. There's a failure to meet other requirements of the FMLA. And there is really no way around it other than this is an individual who knew how to return that form and where to return that form and chose not to until a point after they were terminated.
If the protection's indefinite, but there's an inference of retaliation for at least 90 days after, is it fair to conclude that it's at least 90 days worth?
We believe no, Your Honor.
Okay. All right. Thank you both for your arguments, and we'll be in recess.